Perfect. While we are waiting for some people to come in, I'm going to go ahead and just do a very quick introduction of the firm and myself and let you all know why we're here today. So my name is Caitlin O'Connor. You may see on your screen that I am showing up as Carrie Nixon. As much as I wish that I was the wonderful Carrie Nixon, I am not. So if you know Carrie, she's not here today. It's just me and Catherine. So my name is Caitlin O'Connor. I'm senior counsel with Nixon Gwilt. I am just here for support for Catherine today. But I did want to quickly just let everyone know what our firm is about and also let you know how you can find more webinars like this from our firm. So if you're not familiar with us, our firm is Nixon Gwilt Law. We are a healthcare innovation law firm. All of our lawyers are extremely well versed in healthcare regulations and healthcare laws. And more importantly, we are all very well versed in the challenges and opportunities that come along with starting, launching, and scaling a innovation or software company in this industry. So if you're a digital health company, we're here to talk to you about what your startup needs to know about corporate structure, equity incentives, and financing. I am not the expert on this. Catherine Bain is. So without further ado, as people are still trickling in, I'm going to go ahead and turn it over to Catherine. I know everyone's going to be asking if these slides are going to be available. The slides themselves will not be, but we are recording today and we will make the recording available on our website. So if you miss anything or if you're late or if you know people that weren't able to make it, you can send them over to our website once that's available. Lastly, I will just let you know we have the chat function turned off, but if you have questions, please feel free to use the Q&A function at the bottom of your Zoom screen to submit questions. We will leave about 15 minutes at the end of this to answer any questions that you may have. So, Catherine, take it away.
Hi, everybody. I am Catherine Bain. I am also a senior counsel here at Nixon Gwilt Law. And my practice focuses primarily on representing digital health companies, healthcare data analytics companies, and innovative healthcare providers in their corporate setup and financing guidance and getting created as a company, data privacy issues, commercial contracts, and business strategy, to name a few things that I do on a daily basis. I am very excited to be here today to share some high-level considerations for your companies as you are preparing for your first round of funding. Some of you may be in earlier stages than that, but this will be helpful for you as well. The reason that we created this webinar is that we have clients ask us every day, what kind of structure should I have to be able to, in the future, raise money? What kind of documents do I have to have in place for when investors conduct due diligence? What is founder equity and how much should we get and what should it look like? And then kind of down the road a little bit in our representation of these clients, they will start asking us, what kinds of financing documents should I provide to investors in a kind of seed round of funding? Because of those questions that we get on a daily basis, we felt like a webinar would be really helpful for our clients and kind of the digital health startup market in general, and all of you, to get a high level introduction to kind of all the considerations and information that we pass along to our clients in a much more detailed fashion. Again, it's high level because I can't cover everything about all of these topics in an hour, and I do want to leave time for question and answer at the end. So again, if you've got specific questions, we can try to cover them at the end, but this is meant to be things for you to consider as you are prepping for financing or your first round of funding. I do have to give a quick disclaimer that most lawyers or all lawyers should give at the beginning of any kind of informational webinar. I am a lawyer, but I'm not necessarily your lawyer unless you're already a client at Nixon Gwilt Law. Today's webinar is for informational purposes and should not be considered by anyone attending as legal advice. Before making any decisions with your business, it is always advised to have a conversation with your attorney about your specific circumstances. And we are at our firm are all ready and willing to help you if you would like to seek our advice after this webinar. Okay, so that is done. Most of you will understand why pre-seed prep, pre-funding prep is important, but with our focus today being on corporate governance and documentation and founder equity and things like that, those are not necessarily what most startups are thinking about when they're focusing on prepping for meeting with investors. You're focused on your idea, your market, what makes you unique, how investors can make money off of investing in you, what is your revenue. But what we're talking about today, these foundational documents and foundational decisions, can make that focus possible by incorporating these decisions and this documentation that we're going to talk about in this webinar today. We have seen in our clients that investors have a better impression of your team, which can then lead to either higher valuation or better deal terms or both. It can eliminate unnecessary stumbling blocks in the diligence process and allow you to focus on your pitch and your passion about your company. And it will also, it can help reduce friction in your team, amongst your team, and potentially with your employees or contractors when everyone is on the same page about who owns what, how it is structured. And when everyone is on the same page about that, everyone can focus on building momentum in the company. So we are going to start with, we're going to cover today corporate structure, corporate governance documents, founder equity, and then financing document options for you as you seek investment. And so the first kind of question I typically get from clients is either, depending on their stage, what type of company should I be? Or I started as an LLC in my home state. Should I change to a corporation? This is definitely a question that has a lot of different perspectives from different points of view, from lawyers' point of view, from investors' point of view, and from founders' point of view. However, if you are, this is the point of view that I'm going to kind of utilize here is that of trying to seek investment from a larger investment investor, like a VC or someone that is not just a friends and family. LLCs and C Corps and S Corps are the three main types of corporate structures that our startups can expect to create. So there are other types with when you're dealing with kind of professional corporations, et cetera, but we're going to focus on these three. An LLC has the advantages of being very flexible. It has pass-through taxation to the owners, and so it works more like a partnership. And it has less governance and less paperwork that you're required to, by law, to incorporate into your operations. However, it is viewed as a little bit more clunky when you're providing equity to others, because it's typically by membership. People are joining as partners. When you're getting investors that are not part of a founding team, you may not want them all to be treated as the same as any of the other founders. And so it's also just not as common in larger raises to be structured as an LLC. Often the investors will ask you to convert your company into a corporation. While there's less governance and paperwork, that also means there's less transparency into your founding team's decision making. And often in the diligence process, that is one thing that investors are looking at. An S corporation, which a lot of people have heard of but don't always know what it is a corporation that has the unique ability to have pass-through taxation to its owners. However, it's got some disadvantages in that it's limited to a smaller number of investors. It doesn't always affect companies immediately, but you can only ever have 100 investors in an S Corp. And you're only allowed to have one class of shares in an S Corp. And so that reduces the flexibility in being able to have preferred shares or different classes of shares created for different purposes. And then there's the C corporation, which is the probably most common that we recommend to our clients that are seeking or plan to seek at some point in the next year or so investment. Mostly because it is the most common that investors like to see. And the reason they like to see it is because, one, it has well-defined laws around it. You can anticipate outcomes in any kind of dispute because there are either state laws that govern that, or there are legal precedents set in case law around C Corps, especially in Delaware, which we can talk about. There is a kind of double taxation that startups tend to focus on when they're worried about creating a C corporation. However, that typically only starts affecting investors, or in fact affecting owners of a C Corp when there's actually revenue. When there's no revenue, the company's getting taxed and the owners aren't making any money off the company. There is quite a bit more required corporate governance and documentation of what you're doing, but that also provides investors a lot of transparency into your decision making. There are other considerations for all of these with respect to tax that I'm not going to talk about. So again, everyone has to kind of use their own circumstances to determine what type of company that they are going to create. However, this webinar and what I'm going to focus on today will be on corporations, but the general considerations that we're going to talk about will be the same for any type of company. We also sometimes get a question about whether you should form in your home state or form in Delaware. And if you're forming a corporation, we typically recommend Delaware in general, depending on, there are circumstances where we would not, but they have the most robust corporate law available, and it's just well known by investors. So everyone has a lot of understanding of how things will work, which is why there are so many folks that incorporate in Delaware, and so many lawyers will recommend to incorporate in Delaware. Okay, so that is kind of the corporate structure piece of this, and it's foundational, and many of our clients come to us already formed and already a corporation. However, they may not already have their full set of corporate governance documents in place, or they have some, but not all, or they have some that are signed and some that are not. And there are in diligence specific documents that investors are looking to see. And not only are they checking the box when they are looking through these documents, they are actually, many of them are looking through the substance to determine certain key facts about your company when they're deciding whether they want to invest. The Articles of Incorporation is a check the box. However, you want to make sure your company is in good standing before you seek funding. We've had clients that have let that fall to the wayside, and it's not unfixable, but you just want to make sure that you're in good standing, you're up to date on your fees and your taxes and wherever you have incorporated. The initial action of the board of directors is kind of the key foundational document that helps start up the corporate governance of the company. It adopts the bylaws, it allows the issuance of shares, it appoints the initial board, it ratifies all of the actions that the founders have taken prior to incorporation. And investors are looking at this to make sure a company has thought through all of their kind of startup and setup issues. It's not that there's typically anything in there that is a red flag. There just may be some things missing that you want to make sure are approved by the board prior to seeking funding out, just so that it's in place. One of the things it adopts is the bylaws. And the bylaws are your governing rules for your corporation. They tell how officers and directors are appointed. They give all the rights of those officers and directors. They provide all kinds of other governance of your internal governance of the company. And in Delaware, there are rules and laws about what has to be and what can be included in your bylaws. It also talks about voting rights of shareholders and what happens in the event of a merger or a sale of the company. And when investors are reviewing that, they are looking to see if they're there and that they're adopted, but they're also going to be checking to see if there's any unusual rights there. If for some reason, you have included, some sort of unusual super voting majority right in the event of some sort of, in the event of a sale, they may ask that those bylaws be amended. I mean, you have to anticipate that some investors will ask for amendments in some of these documents, but they are going to be looking at them for substance. Another key document would be the restricted stock purchase agreements for the founders. We're going to spend a little time on the substance of what is in those and founder equity in later in a few minutes, but they are looking at these for the substance. These are actually, the form may be more of a check the box, but they're going to be reviewing the actual executed restricted stock purchase agreements for agreement of the founders on the number of issued shares and the vesting schedules and any rights that you have incorporated for your founders when you're issuing their initial equity. Two other agreements two other documents that are quite foundational and that may appear to be more of a formality, but are in actuality very important to investors to see, are both the confidentiality and invention assignment agreement and the technology assignment agreement. The confidentiality and invention assignment agreements are what officers, directors, and employees of the company should be signing to require them to maintain the confidentiality of the company's trade secrets, other confidential information they are getting, as well as being a contract that requires those employees, directors, and officers to assign any IP and any intellectual property or inventions or anything that they are creating while they are working for the company, not things that are outside of the company, but things that they are doing for the company that they're creating. You want to make sure that your intellectual property is owned by the company. And so that agreement helps solidify that right in the intellectual property in your employees and directors if they are creating anything. The technology assignment agreements are not always necessary, but if you have created any intellectual property that was created prior to the formation of the company, the founders are often, I mean, we often run into founders who have created great IP and great technology, but they haven't formed their company yet. Assigning that formally to the company is quite important. Often our digital health innovation companies, that is a big piece of what their value is this technology they have created. The investors want to make sure that that's owned by the company because that's part of why they're investing in your company. And it is also important, and lawyers look at this, and our clients don't always want to look at it, but you have to look at this from another perspective, and that is, what if someone leaves? And if you don't have these agreements kind of in place from an earlier start in your company, and someone leaves who has created technology and has not assigned it to the company, it can cause issues with respect to having to buy them out, or they retain ownership in IP that really should be owned by the company, and that can cause a stumbling block when you are doing when you are working diligence out with investors, and they see that not all the IP is owned by the company, and sometimes they don't want to get involved in those types of disputes. There are other foundational documents that are more, I don't know if they're all just check the box, but there are other foundational documents that are not included in this list that are more protection for the founding members, the directors and officers, like indemnification agreements where your actions on behalf of the company are indemnified by the company, an initial document called a written consent of the sole incorporator. Usually one person creates the company, but that person then has to appoint a director, and then the initial action of the board would then adopt that consent. You need to get some shareholder consents with respect to the indemnification agreements. You may need to make 83B elections with respect to any vesting shares. Those are more things that protect you as equity holders in your company, rather than, and are more check the box than are substantive, deep substantive reviews by an investor. Okay, so founder equity. This is an art and not, there are no hard and fast rules here, except that you should have it in writing. We work with clients all the time that have come to us a couple years down the road. They've decided what they want to, what their split is going to be, which it depends on how much money maybe someone is putting in, how much sweat equity someone is putting in, how hard is one person may be doing the lion's share of the work, but not putting in any of the money. Does someone have the intellectual property or technology that they're bringing to the table? That is a an agreement between founders to determine what that split will be. But you need to have it in writing, and you need the company to issue that equity to you. One big reason is that if you don't do it early on, when your company is probably valued at zero, or your shares are at 0.001 cents per share, and you wait to issue that equity or do the final documentation until you actually, are valued at, millions of dollars, you can't go back and issue the $0 shares to founders. Founders will have to then pay for the shares at the value at the time of issuance. So you want to make sure that that's taken care of very early on in your creation. One big thing that investors are reviewing when they are checking on the equity that has been granted to the founders of a company is that they want to, one, see that the founders have skin in the game, that they are going to be around to help grow this company, that, what they are, they are, in addition to selling what the, technology or service or, whatever you have created that is unique to the market, when you're seeking investment, you are also selling yourself. They are just as much looking at investing in the team that is creating your product, and which is you, as they are what you are selling. And so while it may not be 100% apparent, they look at the vesting schedules. They look to see that you don't get all your equity up front and you could walk away the next day. It is very common, but again, not 100% of the time, that founders either have all of their equity vest over a 4-year period, or some very large portion, half, 3/4 of it vest over a few-year period. This shows that the founder will be committed to the company. Yes, there are reasons people leave, but they are committed to growing the company and participating in the growth of the company. So when you are determining how much each founder should receive as part of the initial split of equity in the company, you should consider what types of vesting schedules should be put in place and talk about what will show your commitment to the company. In addition to vesting schedules, another thing to consider is what happens if a founder leaves. There are many reasons a founder could leave, some good and some bad. You want to make sure that your documents reflect what happens in those circumstances. Do they lose their unvested shares, or is there a repurchase option that the company has in those unvested shares? Does it matter how they left? If someone leaves for a very good reason, you can there are plenty of documents that, in the event there's disability or some non-split reason, or a non-negative reason that they are leaving, there are some companies that have allowed those founders to retain their vesting, or there are instances where vesting schedules will accelerate, meaning you will, even though it says you're going to get, it takes 4 years for you to get all of your shares, in certain circumstances and under, depending on the likelihood of these things, if in certain circumstances like a buyout, if your seed investment, we've seen seed investments be $100 million. I mean, there's no one way that these initial investments are going these days. They're not all small amounts. So if someone is buying you out sort of from the beginning, and a new board is put in place, or you are no longer making the decisions, or you get ousted, do you want your shares to then fully vest at that point? And so making those decisions early on can protect you as your founding team. But if they are too favorable, or if they dilute an investor's investment or their equity rights, there may be some discussion there between you and the investor. So you just have to kind of balance those considerations. All of these things should be considered by your team and memorialized and signed and approved by the board. Again, just to have it all in place and let the investors know that you're serious, that you're organized, that your team has skin in the game. We get questions once in a while about whether a founder can make a loan to the company. There's often times founders have varying degrees of financial ability, and the company may need an injection of funds, but the company or the group of founders don't want to provide one person that much more equity. So yes, a founder can make a loan to the company and have it be repaid. I have anecdotally heard from some clients that sometimes that's a red flag. I don't necessarily see it as a red flag. I see it as a way that you're showing even more commitment to your company, but then it becomes a debt of the company, and some of those loans get triggered off, like a repayment of the loan is triggered by a specific amount of raise. And so an investor would want to see, how much of their money is going towards paying back a loan. So you have to consider those things when you are making a loan to the company, and incorporate those again into a document that shows what the terms are and what the repayment obligations of the company are. The third area of prep for a seed investment is, I call it cleaning up the cap table. Your cap table should show everyone who has equity in the company, and equity including kind of options or warrants or anything that could become equity in the future. If you are at a point where you are seeking seed investment and you've already gotten investment from friends and family, or one angel or an accelerator has provided kind of an initial investment in your company, you want to make sure that the documentation from especially friends and family, because sometimes they give you money and you might have given them a document, nobody signed it, everybody's okay with that. But once you're going to seek investment, you're going to want to make sure that that money's in the bank and that the documentation is signed, and that those folks' equity amounts, or if they gave you a convertible note or something like that, that those terms are included in your cap table. Employees and contractors are, yes, you want to include anyone on your cap table who has equity or options. I wanted to provide a little bit more information about what you can give to employees and contractors, because we also get those questions a lot from our clients. We've had a few clients come to us and say, I just want to give some options to some people. They've been very helpful to us. They've done some great contract work, but we didn't want them to be around they didn't intend to be around for a long time. I told them I'd give them 1% of the company, or I'd give them X, or whatever they had promised them. But when they come to us and they're getting ready to seek investment, they have not papered that in any way. They've told someone this who no longer is providing any services to the company. And they want to be able to just give someone options, and that under tax laws just isn't possible. So I wanted to give a little bit of just very brief background on what types of options there are, and what their requirements are. There are incentive stock options, and there are non-qualified stock options. Incentive stock options can only be provided to employees of the company. They have pretty beneficial tax treatment under the law, because they are not taxed to the recipient at grant, and they are also not taxed at exercise. The only difference between one other difference between those and non-qualified is that the company cannot deduct the expenses it incurs in issuing those options. Non-qualified stock options can be provided to contractors, advisors, directors, folks providing services to the company, but that are not actual employees of the company. Non-qualified stock options are not taxed at grant, but they are taxed when the recipient of that option exercises the option, and they're taxed on the difference between their exercise price, which is set at the time it's granted, and the value of that share at the time they are exercising the option. One good thing about non-qualified stock options is the company can deduct the expenses from their taxes for issuing those options. All options are a great way to attract high quality talent without providing immediate equity or shares in the company. There's so many of our clients do not have the amount of funds to pay really high quality talent and employees from the start for salaries that are competitive in that person's market. But they are able to give them options which will allow that employee to participate in the growth of the company. So an option really is just the right to buy a share in the future for a specific price. Almost always, I cannot say always, but almost always, options aren't exercised until there is some either really big investment or a buyout of the company. So at that time, the person is able to purchase those shares at a very low price at the whatever the value is at the time of grant, which if you're offering it up at current pricing, it's nominal. And they're able to then cash out at the buyout and participate in that growth of the company. Non-qualified stock options can be treated the same way. We also get questions about when advisors are providing you advisory services either under an agreement or not, and whether and how much equity you should give to them. And that is very much a creature of circumstance. Advisors typically get very little, some small percentage, a 0.25 or 0.5% of the company at that time. But there are some advisors who are providing way more services and may request additional equity than that. They are typically not getting paid money, but they are providing some services for which they would be able to get some participation in the growth of the company. So in addition to kind of taking the time to make the considerations about what types of equity you're giving to folks, you want to make sure that your board resolutions are in place that approve the issuance of these shares or these if your friends and family gave you a convertible note. You want to make sure any grant documents are in place. at the time these folks are employees or contractors. When they are no longer employees, you cannot issue them incentive stock options anymore. So then they lose out on the tax benefits of that. It's not the end of the world, but if you've promised them something like that and you don't put it in writing while they're still an employee, you can't go back and retroactively give them those types of options. Options in particular require a stock option plan to be approved by the company, and that typically sets forth the rules governing the options. It also gives the amount of options that are in the pool created to be able to give to employees and contractors. That does not mean you have to give all of them at the same time, but you're reserving that space basically in your equity on your cap table. And stock option plans often require shareholder approval. So if you've only got a few folks who own actual equity, that's not a difficult approval to obtain. But sometimes you're giving stock options to directors and officers, and because that is an interested grant, like the people granting it or receiving it, that is why you get shareholder approval, because sometimes there are shareholders that aren't part of the board or the officer group, and then they can approve the stock option plan. If you've got outstanding promises that are not papered, you should remedy that as soon as you can. The final area before we go to Q&A, I just wanted to kind of run through the types of investments that many of our clients there's three main types of investments anyway, but the types of investments that you can be prepared to either offer up to investors or for them to push on you. Some of them you may have exactly how you want to raise money, and they may come back and say they want to do it a different way. So my point here is I want to give you a little bit of an overview of the types of investments, but also you should be prepared and understand what you want to raise, what portion of the company, if any, you're willing to give away, and understand all of that before you go to an investor. But also be flexible, because they will push back. The three main types of investments there are convertible notes, safes, which many of you have heard of, but I often find that my clients don't know exactly what they do, or just straight equity in a priced round. A convertible note is a debt of the company that converts to equity on a certain trigger, whether it be a certain amount of money raised or a buyout or something like that. It has a valuation of the company cap set, and it has an interest rate set. These are a little bit more complicated to create, or they can be, but you have, as a founder, a lot more control over what an investor in a convertible note is going to receive in your company going forward. A safe is something that was created out of Silicon Valley and the West Coast in order to speed the process of investment in companies. It is called a simple agreement for future equity. It is simpler because the documents are typically not negotiated. They're just, they use the forms that are available online. But they are not always better for founders. And there have been a couple types of safes or a couple versions of the safe that have come out, some of which are much more detrimental to founders because it has, anti-dilution rights for the investors already built in. Safes give the investors equity rights in a future round of the company. They are not a debt, so they don't have to be repaid at a certain point or at a maturity date like a convertible note would have to be. They act more like an option or a warrant in a future round. And then there are priced rounds where you, as a company, would then have to have a company valuation and agree on the company valuation with your investors. In those, investors almost always get preferred stock in your company. And the preferred stock means that they have additional rights to just regular stock equity holders. They don't just get voting rights. They also will sometimes get board seats, anti-dilution in future rounds, liquidation priority, like they would get if the company goes under, they would get paid before other shareholders. They may get better voting rights. Depending on how much money you're raising and whether you are ready to put a valuation on your company, we see more earlier stage seed rounds happen with convertible notes or safes rather than a priced round. Okay, so that was a lot of information. I understand it was somewhat high level, and there are probably, considerations for each one of your companies that would be different for each one of those categories. But my top 3 takeaways for you would be to get all of your corporate governance documents in order early, and thinking through all the issues and thinking through all the considerations you have to make in order to create those documents. Consider how your founder equity is going to be granted, and not only how to protect yourself, but how to not raise flags with investors in your granting of equity to yourselves as founders. And then take time to understand the pros and cons of the various investment types before you go seeking seed investment. So you can be flexible and understand the risks that if they ask for something different than what you are offering. We have created a fixed fee package for digital health startups to cover more in depth everything we talked about today and some additional offerings. And you can find out more about, we've got a link on our last slide after Q&A that you can read more about that offering. But now we have a little less than 15 minutes. I'm not sure, I have not been keeping up with the Q&A, but I will ask Caitlin if she has gathered any of the Q&A, and if anyone has questions now that have come up during the presentation, let me know.
Yes, great job, Catherine. I am also really quickly just going to have a poll show up for everyone. If you don't mind just quickly responding to the 2 questions that should be showing up on your screen. We just want to make sure that all the information we're providing to you is valuable, and that this will help us improve our content going forward. So while people are answering the polls, Catherine, we do have a number of questions for you. I'm just going to run through them. We will answer them live. If we don't get a chance to answer your question, feel free to reach out to one of us directly and we'll get you an answer. So first question, Catherine, how important is it for founder stock to vest on a schedule? Are there circumstances where founders would not want to agree to that for their equity? You're muted.
I will unmute now. I muted while you were speaking, sorry. And now there's a hailstorm at my house, so if you cannot hear me, I'm sorry. I didn't know it was going to hail today. It is my understanding that it's quite important for founder stock to vest on a schedule. It really does show that you are willing to stick around in order to gain the full value of your company. However, there's always circumstances that you would want to own all the equity in your company without a vesting schedule. I don't think it's very typical, but it does happen. I do see sometimes, especially when there has been a longer period of time to get to the first round of funding, that but the equity maybe hasn't been already determined at that point, that a bigger chunk might be fully vested at that date, and then the rest of it would vest on a schedule.
Awesome. Do I need an equity plan in order to issue founder shares?
You do not need an equity plan. It would just be part of your initial action of your board of directors to approve the issuance, and then you'd need the documents, the restricted stock purchase agreement, to be executed by the recipient, you and the company, whoever is the officer of the company signing those documents. It might also be you, but.
Awesome. What are your thoughts on the value of IP shared between two companies? Are investors likely to invest, or should startups make sure that their IP is owned only within one entity?
That absolutely depends on the circumstances. I mean, we represent clients that have multiple companies, and one owns the IP and the other provides the services, and they license it between each other. It becomes messier when you share IP. However, if it's clearly set forth that everyone's use rights and ability to be able to monetize that IP, it can work. It's just that would always depend on the circumstances.
Got it. Can we legally issue options at a lower price to the advisors than the prevailing than the price prevailing at the current valuation?
I do not think that you can, but that is a tax question. I believe you have to issue options at the time of grant, that they have to be at the valuation, the current share value.
Got it. This is a question I'm not sure whether this may also be partly a tax question. Can you comment on the legal and accounting treatments of options? Well, I'll ask that one first. Can you comment on the legal and accounting treatment of options?
So, as I said earlier in the webinar, I don't know what you mean with the legal treatment of options, but the accounting treatment of options, I mean, for tax purpose, maybe I need more information on what you're trying to get at there. I mean, they are not considered equity in the company. They don't have voting rights. Options don't have voting rights. They are a right to purchase shares at a future trigger point for a specific price.
And is it the case that they're not taxed until the options are actually executed? Or it depends?
So the incentive stock options aren't taxed at grant, and they're not taxed at exercise. The non-qualified stock options are also not taxed when they are granted to the recipient, but they do get, that recipient does get taxed when they exercise their option. I will say, in a kind of realistically, yes, they're getting taxed, but they're not going to exercise the option until they're going to be making money on that exercise. So they're usually going to get paid out, and that they're just getting, their value will just be slightly less because they're going to have to pay that tax on the difference.
Got it. Okay, and do we legally have to issue 1099s for advisors who get options?
I don't know the answer to that question. That's a federal tax question. 1099s are typically for contractors. I don't know if the options portion impacts whether you have to issue a 1099. I think the 1099 impacts the services. I mean, they are getting a value. That's a question I'd have to look at from a tax law perspective.
Okay, got it. If bootstrapping, how should founders price additional investments into the company over time if there are no priced rounds?
Okay, I missed. How would founders price additional investments into the company over time if there are no priced rounds? Are you talking, if you're talking about the founders purchasing more shares and there's no priced rounds, you can continue to purchase shares at the current share value, which could be zero if you haven't raised any money or your valuation is still at zero.
Okay. What are the pros and cons of friends and family versus crowdfunding?
So, Caitlin, you've looked a little bit at the crowdfunding issue. I haven't looked much at crowdfunding. There's new rules around it. I don't know if you want to answer that question.
Yeah, I mean, it depends. I really haven't looked that deeply into it either because it is somewhat new, especially, you know, sometimes in healthcare, doing something like crowdfunding can have different implications than doing it in other industries. So I would say there are probably several pros and cons, and we can talk more deeply about that if you want to reach out to us after. I don't know the details off the top of my head either, to be honest. I think crowdfunding is kind of a different animal than what we've been talking about today. Okay, let's see, what other questions? We may have kind of talked about this before. I think this goes back to the question of shared IP between entities, but in the event that there is a joint venture, how do investors look at that joint venture when making the investment in a company?
I mean, they look at it the same way they look at any company. I mean, you just have to, if you are a joint venture and it's two individual companies creating a joint venture that have shared IP, you just have to have your agreements in place, but that create the joint venture and that very clearly set forth the IP ownership and use rights and all of that. I mean, it's not that investors won't do it. It's just you want to make sure you're very clear and not just come to them and say, oh, we have a gentleman's agreement about it. I mean, that not having it papered is what would raise a red flag.
Got it. I am typing a response. If anyone is wondering whether the webinar will be recorded, the answer is yes, we are recording, and we will post this webinar to our website so you can go back and reference it. You will also get a copy of it sent to your email after the webinar in the next day or two when we have a chance to go back and edit it and make it shareable. All right, we have just about 1 minute left. Is an early exercise provision for NSOs typical for non-founder early employees?
I do not know the answer to that question. I think it depends. I don't know if it's typical or not typical. You would want most options are also granted on kind of a vesting schedule and vest over the time period you want someone to be employed before they would fully get all of their options. I guess it depends on the employee if you want to give them an early out.
Got it. Okay, so I just sent a link to our fixed fee offering that Catherine mentioned specifically for pre-raise startups to help you prep for your first raise and go through some of the things that Catherine talked about today. If you want to click that link and check it out, please feel free to do so. One last question, we are at time, but Catherine, should all founders be board members?
Not necessarily. I mean, sometimes there's only one board member. You know, it depends on who you have available to act on your board. I mean, if it's just you and one or two other people, you can all be on the board, or you can have someone, an advisor, be on your board as a less interested third party. But no, your founders do not all have to be on your board, if that was kind of the basic question.
Awesome. All right, everyone, thank you so much for being here. That is all that we have for you. Please feel free to reach out to Catherine. Her email should be showing on your screen. The link to our fixed fee offering is also on your screen, and I dropped it in the chat, so you should be able to see that. If you, for whatever reason, don't have it, it will be in your email afterwards as well. Any last words, Catherine?
No, but I'm so happy that you guys all attended today. I look forward to hearing from some of you or all of you, and good luck in your funding, your funding seeking.
All right, thanks everyone. Have a good one.